Welcome to the class. In the series of jurisprudence videos, today we are going to discuss about custom part 2. In the part 1 on custom as a source of law, we have discussed what is a custom and how custom, a local custom, is different from the general custom that is common law. Isn't it? If you have missed that video, I'm putting the link in the description box. If you wish, you can go and watch. Okay. And this is going to be a playlist. I'll also be putting the link for the playlist as well. Okay. So today in this video, we are going to discuss what are the requirements for a valid custom. Okay. So let's see. Yes, requirements for a valid custom. What are we going to discuss? We are going to see how and when a custom can become legally binding. Okay, so the first requirement is antiquity. That means the custom must have an origin which is time immemorial. When we say time immemorial, it is explained in this way that it should not be of recent origin, or rather anybody in the particular society should not be able to remember or should not be able to state that from this period the custom has started. That means nobody should be able to remember the origin. It has to be having an immemorial origin. But at the same time, English law has kept a limit for the legal memory. Now what is that? If a custom has begun before 1189 AD, it is considered to be old enough to have a legal validity. Now, what is the significance of this 1189? Yes, that is the year of accession of Richard I. That means if a custom has started after 1189 AD, it is not a good custom according to English law. Now comes to Indian law. We are also insisting that a custom, in order to be valid, has to be ancient. But at the same time, we have not kept a limit for the legal memory. There is no particular year which we state that a custom has to be originated before this particular year. But at the same time, we reiterate that in order to make a valid custom legally binding, it has to have an origin which is as ancient as that of 2, 3, 4 centuries old. Okay. Now this was held in Mount Subhani versus Nawab. This case law is reported in Indian Law Reported in 1941, which set the law that we accept customs as a source of law, but that particular custom must be old enough to have considered as a valid custom. Okay. Now, what is the next one? Yes, reasonableness. We all know that reasonableness is a required standard not only for custom, for all the laws, isn't it? Yes, but at the same time, a slight problem arises with custom is that customs are originated at a different period of time, and therefore they might be only fitting to the standards of those people who lived at that time. And therefore, each and every custom, before being accepted as legally binding, we need to test it whether it is acceptable for the current generation, for the standards of the society with which we are living. Okay, so reasonableness and rationality to the present generation is a requirement for considering a custom as to be valid. Okay, so even though the custom is very old, even though it is being practiced for generation, we have to always try and see whether this will suit our current standards of society. Okay, then it has to be in conformity with statute law. We know that Indian Constitution is the basic legal document in India. So whatever is the law, whatever is the regulation, or whatever may be the custom or usage, that has to be within the limit of the Indian Constitution, or rather that has to be in conformity with the values which we exhibit through our constitutional principles. Okay, not only Constitution, the custom which is followed must be in conformity with any law passed by the parliament or the state legislature. Okay, now compulsory observance. That means just because there is a custom or it is old, it will not become a law if it is left to the people to observe it. That means everybody should observe. The custom must be binding on everyone. I'll give you an example. Suppose a village has a river which is flowing through the village and a bridge is also constructed. And village has a rule that everybody, every member in the village has to contribute yearly towards the maintenance of the bridge. Okay, this will become a custom if it is practiced for year, if it is practiced for generation and for a longer period of time. But at the same time, if the option is given to the villager, if you have money, you contribute. Those who do not have money need not contribute. Therefore, it will not be qualified as a custom because it is not compulsory on everyone. It is just optional. It is for the villager to decide whether they should follow the custom or not. In such cases, that is not qualified as a good custom also. Okay, so from this, today we learned that customs can be source of law, customs can be legally binding, but for that a custom must be very old, a custom must be reasonable, and a custom must be in conformity with the statute law, and more importantly, it must be binding on everyone within the community where this custom is applicable. Okay, so I hope it is clear to you. If you have any doubts, you need clarifications, please make use of my comment box. I'll be very happy to help.